Luciana, if you could admit people as they come in, that would be great.
Sure.
Hello, everyone. I think we'll go ahead and get started. My name is Christian Jorgensen. I'm one of the legal advisors in international humanitarian law at the American Red Cross National Headquarters in Washington, D.C. I also help manage the IHL dissemination program. Today, I'm very excited to have our speakers, Jonathan Sommer and Ezequiel Heffes. Jonathan is with the Danish Red Cross as an IHL legal advisor, and Ezequiel Heffes is with the organization Geneva Cause as a thematic legal advisor as well. Together, they recently published a report on inviting non-state armed groups to the table, and that will be the focus of today's discussion. If you could stay on mute during their presentation, and please enter any questions you have in the chat. Those will be recorded and asked after the presentation. We will also have a brief discussion led by our Massachusetts IHL lead, Luciana Wozniak from the American Red Cross Massachusetts region. So with that, I'll pass it over to you, Jonathan. Thank you again for joining us, and Ezequiel as well. Thank you.
Okay, thanks so much, Christian, and many thanks to American Red Cross, your colleague and my colleague, Randy. Excited to be here, well, this afternoon for me, I guess around noontime for you on the East Coast in the US. We decided that I would start off today because Ezequiel has just taken the red eye from Geneva to Buenos Aires, and we thought we'd allow for a few minutes for that extra shot of espresso to kick in so that he can take up his part of the presentation. So as Christian said, Ezequiel and I decided to write this paper together, and part of the motivation for both of us is that we've spent a good chunk of time over the past 15 years or so engaging non-state armed groups on issues related to international humanitarian law. And just to be very clear, what we mean by non-state armed groups is, well, common expression, one man's terrorist is another man's freedom fighter. So what we really mean are what groups that could be labeled as insurgencies, rebel movements, self-determination movements. Again, terrorists, we're not here to label. We're here to use what might be international law terminology, which is non-state armed groups. So for me, it was really interesting one time several years back when I was having a discussion with a representative of a non-state armed group on issues related to humanitarian law and some of the challenges that they faced. And at one point I said to my interlocutor, they'll be really interested in hearing about that in Geneva. And I could really see his eyes light up saying, somebody cares about our opinion, that matters. And I think that is a bit of the impetus for this paper and for some of the notions of what it means to engage not just at a level of one-way communication, but at a level of really trying to understand the perspectives of these parties to conflict who have obligations under international humanitarian law. So what the starting point and the premise for this paper or for our case is that non-state armed groups, whether anybody likes it or doesn't like it, are stakeholders when it comes to situations of armed conflict. They have influence over the protective outcome for both fighters and civilians alike. And therefore, what we're advocating for is to treat them as such, to treat them as stakeholders. Now, maybe a few things about what we mean in terms of inviting non-state armed groups to the table. So we have an illustration of two different tables in our title slide. And this shows the diversity that we're coming towards. The first table on the left you can see is actually from the negotiations at the diplomatic conference leading up to the adoption of the additional protocols to the Geneva Conventions in 1977. A very formal process. And in fact, Ezequiel will tell you a little bit later about the involvement of non-state actors or non-state movements in this particular conference. If we look at the picture on the right, we have a much less formal process, but a very important one nevertheless, where representatives of non-state armed groups were invited to Geneva to participate in a thematic discussion on issues of international humanitarian law. And again, Ezequiel has clarified this to me at one point, but maybe you can jump in again and say, did we have UN representatives at that table? Did we have state representatives at that table?
Yes. So we had different international organizations. Some UN staff were there, and we also had some states as well and regional organizations.
Okay, great. So I would say that over the past several years, it's almost become mainstream to engage non-state armed groups on international humanitarian law. This hasn't always been the case, but there's been a lot of work that's been done by the ICRC for one, by Geneva Call for others, by UN organizations. It's been addressed in the protection of civilian discussion at the UN Security Council. In fact, I think the last time I was in Washington, I was invited to both the State Department and the Pentagon to give impressions and discussions on this notion of engaging non-state armed groups on respect for international humanitarian law. What we're trying to do is to take it to the next level, to say it's one thing to engage and to have some discussions on what is the law and how can they implement the law. It's another thing to reach out when the law or particular standards are being developed, worked through in terms of what good practice is. It's another thing to say, you as stakeholders should be involved in these conversations because we're going to learn something from it. So this is in fact what we're advocating here today. So what we've done is we've developed a little theory of change, because what we love doing as humanitarians is working backwards from the humanitarian problem. So you can see on the left here, the humanitarian problem is, or what we're trying to do is alleviate conflict-related suffering. Now there's many ways to do that, and our proposal is not going to cover all that ground. Lots of other things have to happen. But if you follow my blue line there, you can see that one thing that would need to happen would be non-state armed groups comply with humanitarian norms. And actually one thing I'm going to say, we're going to use here the term humanitarian norms to mean IHL plus relevant human rights law standards, as well as other mechanisms and policy standards that have been devised towards the protection of civilians. So we're looking at a whole bundle, some being legal obligations and other being policy standards towards the protection of civilians. In order to get this compliance, one thing we have to realize is that international humanitarian law is self-regulatory. What that means is that there's no referee out there blowing the whistle every time a foul is committed saying, okay, now it's time to go to the penalty box. Unfortunately, this doesn't exist in international law, and particularly in humanitarian law when we're in the middle of wars. And that means it's up to the parties themselves to regulate themselves and comply with the law. Now, of course, we may have accountability processes after a conflict has ended, or sometimes maybe even during, but for the most part, it's going to be up to the parties themselves. And so if we move back from that, how to get them to comply, again, there'll be many things that can be done, but two things that we think then are very important are that the norms have to be realistic for the particular parties who are bound by them, and they have to feel a sense of ownership over those norms. So in order to then think about, okay, well, what would have to happen or what could contribute to that? Again, it goes off in many directions. There's many contributing factors, but one important thing there is then their participation in the development of the law and of these standards. So this is really the theory of change of how we want to get from, well, in this case, from Z to A, as I've explained it, but it's really from A to Z when we think about how we involve them in processes. So there are also some challenges. We're going to address these challenges a bit more, but I'm just going to bring them up now. So one of them is clearly the fear of granting political legitimacy to these groups. Ezequiel will talk a little bit later about the legal legitimacy, but certainly particular states are very concerned about the legitimacy that sitting at the table with such groups would grant, or would the perception it would grant of legitimacy, or even just having discussions on legal standards at all. Another issue is, well, I take these next two together, their motivation and the notion of instrumentalization. Why do they want to talk to us? Do they even care about these standards and this law? And I think what I would say here is yes and no. Some will and some won't. But we can look at it in the same way that we would look at having these discussions with states, because as we know in our experience with states, some care more about complying with these standards than others. Some do it for certain reasons that are less than humanitarian. Some do it to manipulate, but others also do it for the sense of a legitimate protection of civilians and other standards that are compliant with IHL. So yes, these challenges exist and we need to identify them, but we also think that they shouldn't prevent these types of processes from going forward. So here's the issue that we face, because I mean, we're not just doing this for the sake of doing it. There are real lives at stake. If we look at the top here, there's 70 million people or around 70 million people according to the ICRC who live under control of non-state armed groups. So what does that mean in terms of the human rights of these people? What does it mean in terms of when IHL applies in conflict situations? How are they protected? How are their rights assured? How do they get security? How do they get essential needs met? Something else we can look at in the right is protection of children. What does it mean when, for example, it could be issues of child soldiers, it could be issues where children are fleeing abusive environments, where children, we've seen it in situations where women particularly feel that they can be more empowered if they're associated with a fighting force than if they're in traditional cultural environments. So what does that mean? How do armed groups react in that situation if women come to them for a sense of empowerment? We need to understand their perspectives on this. What about the use of weapons? We know that armed groups often use improvised explosive devices. It could be in populated areas. Why do they do that? Are they willing to do it under only certain circumstances? Are they willing to limit their use of this? We know that they also they may detain civilians, and they may detain captured enemy soldiers as well. So for example, what does it mean in terms of ICRC having the ability to visit these detainees in order to ensure that they are being treated humanely? Now, armed groups might say, well, we don't have a problem with ICRC coming, but we want to make sure that they're not followed so that our enemy doesn't know where we're located and others are located. So it's only by having discussions with them and understanding their perspectives that issues like this can come out. Now, what we've seen over the last year is we've seen some really interesting developments when it comes to the COVID pandemic and what it means in terms of borders or the lack of borders in terms of how a pandemic reacts or doesn't respect borders. So I think with that, I'm going to hand over to Ezequiel, and he'll take you through some of that and then the next stage of the presentation.
Wonderful. Thank you very much, Jonathan. And let me echo your words. Thank you. I'd like to thank also the American Red Cross for organizing today's activity. And of course, to the participants who have come here to hear us talking about armed groups and international law. It is great to see such a big number of people interested on the topic. So I'm just gonna say a few words about Geneva Call before I speak about COVID-19 and armed groups. Just as a matter of introduction, I'm a legal advisor at Geneva Call, that is a humanitarian non-governmental organization that engages armed non-state actors, armed groups on issues of international law. And so that's, just to put it broadly, the focus of Geneva Call is the engagement exclusively of armed non-state actors on different thematic areas such as child protection, sexual violence and gender discrimination, healthcare, prohibition of using landmines, protection of cultural heritage, different topics. And a few of the activities that Geneva Call has undertaken in the last few years are included in the analysis of today's presentation. So specifically about the COVID-19 crisis, what we saw, it was quite interesting because last year at the beginning of the pandemic at Geneva Call, we realized that most of the attention that of the international community was obviously on states and what states were doing with respect to their own citizens and the COVID-19 crisis. But then at some point, we started identifying that certain groups from all around the world were taking similar practices as those of states. So for instance, they were establishing lockdowns, curfews, they were restricting movements from one border to another border, such as they were asking people not to leave certain areas. They were closing business. They were even asking for vaccines or asking for tests in order to actually undertake their own test to the population living in the territories. And this is important because a recent study by the ICRC has actually came out saying like between 60 and 80 million people live in territories controlled by armed groups. So a part of the reflections of today activity and the paper is actually is how we address this situation, how we address this number of people living in those territories. So in the COVID-19, this was evident. And it's interesting also to notice that some groups, some non-state armed groups have already received vaccines, for instance, and are distributing vaccines in the territories they control. So again, just as part of the reflection, because this entail a negotiation with certain states. So it's yeah, I thought it was interesting to note it. Shall we move to the next slide? So did it move? And
yeah, sorry, I'm just having trouble and the slides don't want to move. But I might have to. Okay, that was a manual attempt.
Yeah.
There we go.
I think, yes. So all these discussions in terms of some of the points that Jonathan was raising and some of these issues related to the COVID-19 and how armed groups have been dealing with this, raises issues of how international law actually deals with non-state armed groups in conflict settings. And there are three reflections that we thought that were relevant for the purposes of our piece and for the purposes of today's discussion. So the first one is that sometimes what international law requires from the parties to the conflict is not reflective of the reality of non-state armed groups. And this is, I'm actually a lawyer, and you know, when in law, and especially when we qualify a situation as an armed conflict, as a non-international conflict, there is this perception that parties to the conflict, they have the level of organization required to respect all the obligations contained in these legal regimes, in IHL specifically, and that's not always the case. They often lack the knowledge of these obligations, and they lack, therefore, the capacity. And I always repeat this kind of phrase, but you know, it's like in any given society, the number of people who actually know about law is very small. The number of people who know about international law is even smaller. The number of people who know about international humanitarian law and know the differences between IHL, and now I'm going to deal specifically with other legal regimes such as international human rights law or even international criminal law, is even smaller. And in the IHL sphere, there is this kind of assumption that once we say this non-state armed group has reached a certain level of organization and there is a level of intensity, then they are bound by a set of rules. And then they have the knowledge of those rules and they have the capacity to apply those rules. And that's not necessarily the case. So this is one of the challenges of the consequences of not involving non-state armed groups in legal discussions, because we don't know what the problems are and what are the problems that they face when they try to comply with the law. Then the law sometimes turns to be a bit unrealistic. The second point is related to the different legal regimes. And I was just saying that it's difficult sometimes to identify the differences between IHL and human rights law. And you can tell that for armed groups, it's even more difficult because some issues are actually dealt by different legal regimes. So I always give the same example, it's like, and I've been in discussions with different groups that are not necessarily against international law, they against certain rules, and they against certain rules of certain legal regimes. So I was in a discussion with a group in Colombia, and they were saying, well, it's very interesting because human rights law, for instance, establishes that armed groups cannot use and recruit children below the age of 18. While Additional Protocol 2, an international humanitarian law treaty, establishes that the minimum age is 15. And what the group was saying is like, and the Rome statute says that 15 is the age. So it's like, if you are using or recruiting below 15, that's a war crime. And the group was saying, listen, we take the 15 years old standard. So we are very much in accordance with the Rome statute and with the Additional Protocol 2. And human rights law, well, that's a different story. So it's interesting because for them, it's also part of the reflection. And the last point that I want to make here is about legitimacy versus perception. And some of the points were raised by Jonathan before. There is this fear in the international community that even speaking about non-state armed groups may raise issues of legitimacy. You might be legitimizing their goals. That what we really want to kind of make it clear is that when we speak about international law and non-state armed groups, what we're doing is we're binding them by a set of rules. We are constraining their actions. They're not free to act. They're actually bound by a framework, by certain rules, and there is no issue about the goals or the purposes of the struggle. It's mostly in terms of they're obliged by certain rules. They're duty bearers. So that's kind of the point that we wanted to make here. And then there's a last point that in terms of how to overcome this, I think, Jonathan, if you click again.
Okay, I'm gonna have to do the same process again.
Don't worry. I can keep speaking anyway. So what you're seeing in the picture on the right is a court by the LTT, the Tamil Tigers in Sri Lanka, and that's actually another of the challenges that we see when we deal with armed groups is the great variety of non-state armed groups around the globe. Some groups actually have set up, that's the point, have set up tribunals. Go back once again. Yes. One more. And we click again. So the last, yes. So, I mean, the variety of non-state armed groups, some groups have greater capacities than others. One of the, in terms of legitimacy and perception, but also the problems related to the applicable legal framework, is creating ownership so that armed groups are aware of their international obligations. They can undertake, they can assume the responsibilities that those obligations come with. And realistic frameworks, because what happened and what is still happening is like there are many legal discussions that are taking place in different spheres, and most of the times the views of non-state armed groups are not even listened to. So if we go to the next slide, what we did here, we tried to compile on table here, the table that you see on the left, some of the current processes that have involved non-state armed groups in one way or another. So I'm going to go very quickly now. So we have identified 5, and this is based actually on some. Actually, it's adapted from a model a public participation spectrum. Is a model actually that we have adapted towards the goal of identifying these processes. And we have identified 5 different processes. One, I mean, actually they go from left to right, and they increase in the level of participation of non-state armed groups in norm development processes. So if we take Inform, this is kind of like the basic activities that humanitarian actors do when they deal with non-state armed groups. They go to conflict settings and they disseminate IHL norms and other basic standards, legal standards to non-state armed groups. So with the goal of increasing the knowledge and the awareness of non-state armed groups of the law. So this is classically what the ICRC does, and you can see this picture from Mali, but also Geneva called us. And nowadays there are more organizations doing this. So it's simply dissemination activities. When we go a bit further, then you see that some organizations are consulting. So the goal in this second step would be to obtain and share feedback from non-state armed groups on their perspectives of the law. And we have different cases, different examples. You have one here, which is the ICRC safeguarding the provision of healthcare report that was published, if I'm not mistaken, in 2015, that they interview more than 30 groups in order to get their views on issues related to healthcare. And it's interesting because in the end, the ICRC came up with a model unilateral declaration towards that goal. So you can see that there is no state participation. So it's merely consulting armed groups about their views on this topic with the goal of making them public, so the international community is aware of this. The third one is to actually involve non-state armed groups. And examples were put forward by Jonathan before. So the idea is to exchange the different perspectives between non-state armed groups, experts, other key stakeholders on legal norms. So for instance, at Geneva Call, every couple of years, we organize meetings where we discuss about legal issues with non-state armed groups. So the report that you see on the right, it was a report that it's from a meeting we conducted last year on the conduct of hostilities. So we brought 4 groups from different places of the world to Geneva to discuss how they apply the principle of distinction, how they apply the principle of proportionality, and how they apply the precautionary measures they have to undertake in conflict settings. And we bring other key stakeholders, so international organizations. So we kind of have an open table discussion about this. So again, you have more people being aware of the challenges that armed groups face when dealing with the law. The fourth one is I'm sorry if I'm going fast, but I think it's like the time is pressing us, and there are many more interesting stuff to deal with. So the fourth one is to collaborate. So the idea, again, is to include non-state armed groups around the table in normative and compliance processes, but then they would be excluded from the final decisional process actually. So the example that Jonathan shared at the beginning was typically the national liberation movements in the diplomatic conferences that led to the adoption of the additional protocol. So you have more than 20 national liberation movements discussing with states on the content of the additional protocols. They couldn't vote in the end, but they were present and they actually raised their voices. And it's interesting when you go to the diplomatic records, because you see the exchanges between the different states and how some states were very much in favor of having national liberation movements. Some states even saying it is good to have them because that turned this discussion more realistic. And this is back in the 70s. But again, they couldn't vote in the end. I mean, there is one article in Additional Protocol 1 that allows certain certain national liberation movements to make a unilateral declaration and be bound by these treaties, but they couldn't vote for the adoption of the protocols. So states here are actually aware, they participate in this collaborative exercise. But again, and non-state armed groups at the same time, they feel that they're treated valuable to a certain extent because they are invited to discuss together with states about the content of international treaties. And the last one is to actually empower. So this would be to fully incorporate non-state armed groups to the table of negotiations. And here we have not had any case yet so far in which non-state armed groups would actually be sitting with states on an equal foot. But of course, we believe that that could be an entry point to enhance the compliance of international humanitarian law. And one point that I want to stress before I finish, and I give the word to Jonathan, is that we're not naive. I mean, of course, there are many different groups with many different goals. Some of them are going to be more difficult to bring to a table of negotiation. I mean, some of them are more willing because of different objectives. They might want to be actually be brought to a table of negotiation. Others, it's going to be more difficult. Jonathan.
Okay, thanks, Ezequiel. So yeah, let's get to the point. I mean, I think to transition from that, I think if one of the things that we do is bring it into our own experiences, certainly we all know what it's like to either feel included in decision-making processes that affect us or to be excluded from them. We know how it motivates us or demotivates us. And so this is something that we think on the collective front is very important in understanding how these processes could work. And as Ezequiel just showed, how they have worked sporadically in the past. So what we've tried to present here is a strategic model based on these progressive levels of participation moving from left to right. And then think about, well, what type of processes are there and how high is it realistic to aim in these particular processes? Now you can see that some of them aren't applicable. Like for example, when it comes to IHL dissemination, well, it's a one-way street. All it is about informing. And so the other levels aren't necessarily relevant in that initiative type. But of course, the further we go in the initiative type towards actually formal legal processes, the more the levels of participation could be involved. So we look at policy reports and we say, well, for example, in any policy report, particularly if states are being consulted, then there should be efforts to also reach out to get non-state armed groups' perspectives as well. I mean, it may not necessarily be in the same report, and that's what you saw in the ICRC example. There was one report on how do non-state armed groups think about the norms related to healthcare, and there was another with respect to states. But this is something that we feel should become more knee-jerk, at the very least, when we gather information on what the parties to conflict feel about particular norms in humanitarian law and beyond. So, we can have expert meetings without states where we can push the bar a lot further because, of course, if states aren't participating, we don't have as many constraints about bringing them to the table and exchanging, particularly with experts. It can also happen in expert meetings with states. Often this will be in more regional settings where you have states that may be actually supporting non-state armed groups. Like, for example, we've seen this in the context of the Syrian Kurds, where many states have been working with them, supporting their armed forces, but they still remain a non-state armed group. So in that case, it might be easier to bring states on board when they're actually working with particular armed groups. We have good practice and examples of good practice in policy processes. For example, you have one happening right now, an Irish-led process on explosive weapons in heavily populated or in populated areas. So we have consultations where states are being consulted, but again, there's no effort to actually bring non-state armed group perspectives into the consultations. Now, we're not asking here that they actually show up at the final conference that Ireland hopefully will hold when the corona crisis is well enough beyond us. But there are ways that their perspectives could be brought into the consultation process and put onto the table so that everyone is aware of them and that they also, again, feel that they have some ownership in this process and an eventual outcome if for example, if a document is adopted, a final declaration is adopted, at least it could be expressed in a way that non-state armed groups could also endorse that. And it's not only focusing on addressing states, because of course, if it's only addressing states, it's not going to solve the problem. One thing that I'll quickly talk about is the Red Cross and Red Crescent International Conference that happens every 4 years. This is interesting because all states attend, as well as the components of the Red Cross and Red Crescent movement. We, as the Red Cross and Red Crescent movement, are bound by our humanitarian principles of neutrality. So we have no problem in bringing all parties to conflict into these discussions. But of course, that's trickier when states are involved in the discussion. We do feel that this is an area where, again, we could work on reaching out, bringing their perspectives into the conference so that everyone is the wiser, and also so that there is this sense of inclusion we're engaging as a Red Cross movement with armed groups every day. And for them to feel that they're also included at the policy level, we feel is also important. We should have said very clearly at the beginning that we're speaking in our personal capacity, which I am when I make these statements. But it's something that we would like to see more discussion, more contemplation about. And then, of course, when it comes, the most challenging areas when it comes to formal legal norm development. Ezequiel spoke about the particular state situation of the diplomatic conference in 1977. That was really a special situation because you had decolonialization going on. You had these national liberation movements that had a lot of political backing from many states in that context. That's what allowed it to happen there. We're not necessarily saying that they should come to that table, but even in these formal legal development processes, we do feel that there's the possibility to consult, to bring their perspectives into the discussions, such that, again, so that we are the wiser for trying to make these rules that need to be realistic for all parties to conflict. So this is the strategic model that we are proposing, and that we encourage those who are involved in these types of processes, or those who convene these types of processes, to consider. And then we'll just close off with 3 key takeaways, because we do want to leave some room for discussion here. The challenges of the future will not be met with the strategies and the mindset of the past. We're facing that in so many of the challenges, from climate change to other things. We need to start not being locked in how we've approached things in the past. We need to think about how are we going to move forward in the future. And this is one way that we think needs to, that we can reflect upon this. Obviously, non-state armed groups are part of the problem in many situations, but they can also be part of the solution. So let's harness that in terms of them being stakeholders towards the solutions. And again, finally, what we hope we've made clear is when we talk about bringing them to the table, we're not only talking or necessarily talking about formal lawmaking processes. There are many creative ways to bring their perspectives into the table. So let's make the effort to do that. And we feel that that will create better humanitarian outcomes in the end. So we're going to leave it there for now. And we look forward to a discussion now.
Thank you, Jonathan and Ezequiel. This was such a great presentation. And for me particularly, it was very illuminating to read your paper. And you raise a great point, arguing that humanitarian norms should be realistic, and that including non-state armed groups in the process of norm development can generate a sense of ownership that may contribute to better compliance with humanitarian norms. It was also illuminating to hear how these groups are currently addressing COVID-19 problems in the territories that they control. I think that was a great point that you raised. I have 2 or 3 questions for you, and then I'll open the floor for questions from our participants. For participants, please feel free to add your questions to the chat or raise your hand, and we'll get to you in a moment. So my first question, I would like to go back a little bit to that problem of legitimization. And from your paper and from your presentation, you explained that one of the main roadblocks for increasing dialogue with non-state armed groups is the issue of legitimization, and that states fear that inviting these groups to the table will legitimize their goals, which are often a direct threat to state sovereignty. How should humanitarians address this issue with states, are there any recommendations on a practical level, like on how to balance the political considerations of states at this moment with humanitarian concerns? I think that's my first question for you.
Well, I think I'll start off here, and I think Ezequiel might jump in with the notion of what in fact is being legitimized. But we're operating in a context of a lot of counter-terror discourse these days, and that makes it even more challenging. So again, as humanitarians, one of the things that we want to do is we don't want to delegitimize counter-terror discourse, but we want to take this out of it, because in the context of humanitarian law, you don't have terrorists or good guys or bad guys, you have parties to conflict. And that's one way to think about the legitimized or the notion of the need to engage because they have obligations under this body of law.
Yeah, I mean, just to add two things. I mean, it is, of course, one of the challenges. I mean, the first point is there shouldn't be a generalization with respect to non-state armed groups, and there shouldn't be a generalization with respect to states. It's not every state is against discussing with non-state armed groups. Geneva Code, for instance, is mostly funded by states. So it's not that, and many states have sat down with non-state armed groups to discuss about humanitarian norms through other different means, special agreements or peace agreements. So it's not necessarily that every state is against it. Of course, there are states, some states are against discussing with some groups, mostly those that are based in their own territories. But I think, I mean, and I don't want to repeat what Jonathan said, but I think it is key in terms of focusing on the law. It is actually a humanitarian message that we are trying, or the humanitarian organizations are trying to convey. So this should be clear. I mean, having said that, the legitimization is given by the fact that the non-state armed group has reached a certain degree of organization and it is a party to the conflict. So if you're discussing about international humanitarian law with a non-state armed group, well, I mean, that there is an organizational issue that is being recognized there, and there is a protracted level of violence that is also recognized that it is there.
I'll also jump in here and say they've also shown some responsibility on this issue, and what I'm talking about here is Geneva Call every 4 years or so organizes meetings of signatories to their deeds of commitment. So essentially what that means is they bring a bunch of non-state armed groups together and also invite UN officials, for example, UNICEF, OHCHR, the Human Rights Office. The rule at these meetings is that they do not politicize them. That's the ground rule. They don't talk about political issues. They talk about humanitarian issues. And almost to a T, they've shown that they're willing and able to respect that rule and not make big, grand political statements about their objectives, but to stick to the humanitarian issues. So it shows that they're also willing to take their responsibility in this discussion as well.
Thank you. Those are great points, especially on the conversation about keeping it on the lane of humanitarian concerns and not involving political issues in this discussions, is also as non-state armed groups as right bearers within the IHL context during an armed conflict. So that's a great point. And building a little bit upon that, what do you see the role of the UN in this process of including these groups in armed development processes? And also you can include regional organizations in that as well, if you think like they have a specific role they could be playing in this process, or even in advocating for states to bring these groups to the table.
Should I start now? And then, yeah, I mean, so the first thing, and I guess I speak on behalf of both of us, is we don't work for the UN. So this is kind of a tricky question because our perspective is an external perspective. But it's interesting because the UN has created certain mechanisms through which it is directly engaging with non-state armed groups on international law. They might not be discussing in terms of lawmaking or norm processes development, but they are sitting down and signing action plans on child protection issues with non-state armed groups. And many UN agencies on the ground, when they have to access a territory controlled by a non-state armed group, they have to engage with that non-state armed group. So again, I guess it really depends on how you categorize that engagement. So the presentation we've been trying to focus was mostly on norm development processes, but that doesn't mean that the UN, that there are no other, I mean, we're not trying to exclude other processes that are taking place. Of course, again, when a certain international organization tries to access the territory controlled by non-state armed group, there has to be a certain level of engagement with that group on the law.
And I'll just say on that a group of UN special experts has just recently, I think it was last month, come out with a statement on human rights considerations of non-state armed groups, and a bunch of recommendations that they make to states, to armed groups, to other actors. And while they don't specifically make the recommendation that we're making in terms of the involvement, the gathering of perspectives, I think a lot of what they say leads to the conclusion that it's really important that we do this, because in order for the objectives that they're aiming towards in that statement to come out, these are the types of things that we need to be able to do in engaging them. They make it very clear that there's a lot of gaps, particularly when it comes to human rights, potential obligations of non-state armed groups. So there's a lot to learn, and we need to engage them in order to understand what it is we need to learn.
Those are great points. Thank you so much for building on that. And as a follow-up, because I asked for the role that you envision for the UN, your paper mentions that think tanks and the civil society actors could have an important role to play as conveners, and then you use the Safe School Declarations case study, which was very important. And I think, Christian, someone in the chat asked for a link to the paper. If you can share that to everybody, that would be great, so they can read this. So the case study mentions that there is a gap between the role that civil society was playing as conveners, and then when that was to transfer to state level, there was a little bit of a disconnect there. Do you have any practical recommendations or how civil society should engage to bridge that gap at this point?
Yeah, I think, having been involved in that process from the beginning, but not at the end, you saw, and this is, going back 10 years ago now. So again, this isn't necessarily something new, but you had quite a bit of understanding of the actors from the beginning. So the process was initiated by civil society, but at the beginning, it did involve a few concerned states. It involved some UN actors and others. And there was certainly an appetite to say, well, yes, we want to make sure that this declaration towards the use of schools for military purposes, to try to avoid the use of school for military purposes, that it should be open and inclusive of armed groups. So I think what happened was, partway down the line, the process was taken over by a champion state. And this is very important because that provides the momentum for states to take it seriously and to discuss it. But I think what often happens is we lose sight of the issue of the involvement of gaining the perspectives of armed groups towards the outcome of any particular process. And I think that's what happened there, because all the stakeholders got very excited. Okay, we have a chance to get this driven. We have a chance to get this adopted by states. And then they lose sight of, well, hold on a second. What about doing it in a comprehensive way? How can we do it in a creative way so that they, again, don't necessarily need to sit down at the same table, but maybe that we have parallel processes that can gather perspectives here, gather perspectives there, have a single outcome document that everybody can endorse. So I think that's what we really need to do as we develop new norm-making processes, to have a checklist from the beginning where this is a key factor, and then say, okay, what type of process is this? And then we can decide what would be the most appropriate way to involve their perspectives.
Thank you, Jonathan. I'm receiving quite a few questions already on the chat, so I will open for discussion. And I already have one here from a participant that asks, on a more practical level, I think they wanted to know if when this engagement with non-state armed groups are happening, if they are ever hesitant to make the commitments because they believe they may still be held criminally liable for their actions, or if they normally want something assurances or maybe combatant privileges that the law doesn't provide to them. Do you have any insights on that you could share?
Should I start? Yes, I guess so. It's interesting. I would say it's actually normally it's the other way around. So I mean, it's a much deeper question on why armed groups commit to respect international law publicly, and often the reasons are related to their public reputation. So there is an issue of, I mean, not often, but it's like most of the cases are issues of public reputation. So they are precisely trying to look as a serious actor within the international law. And this is one of the reasons why they publicly commit to respect to a certain set of rules. Having said that, I mean, in the process of engagement with Geneva Code, we're very clear that this is not going to preclude that they face criminal actions. I mean, of course, the state, may criminalize any individual who challenges the monopoly of the use of force by that same state. So, yeah, I mean, I think it's separating the humanitarian messages from the more use ad bellum, internal use ad bellum perspective, the internal use of force perspective.
Yeah, because Ezequiel, they're setting themselves up for scrutiny by taking on the commitment. So in fact, by not, they could hide in the weeds and, avoid accountability by hiding. But in this case, they almost set themselves up to saying, okay, come and see what we're doing. And they actually often agree to monitoring of the commitments that they make.
But also this might be useful in terms of, for instance, looking for a political recognition in terms of peace discussions. So when they commit publicly through certain means, again, they're considered as a more serious actor, and perhaps they're facing a peace process, then, they perceive or they show themselves as a different actor than just a mere criminal group.
Yeah. And of course, we're not saying that they only have humanitarian motives. We recognize that they're going to have diverse motives, many of them winning hearts and minds. But again, states will have diverse motives as well. And what we're looking for here are humanitarian outcomes.
Great, thank you so much for answering that. Another question that we got here is about actually cyber-based attacks, and if there are any efforts going on in that realm of preventing, of engaging with non-state armed groups in cyber warfare.
Well, I guess it's going to be more challenging, because in terms of identifying the organizational structure of the group is more difficult. In the end, I would say traditional groups, physical groups, I mean, I'm not saying it's easy. I'm saying I think it might be easier to identify the leadership and for them to internalize certain humanitarian messages. But this is my quick thought about this.
Yeah, I mean, I think that they will clearly, I imagine there are already cyber operations that armed groups are undertaking. And it will be interesting how this discourse is just developing at the global level. So this is kind of the next step when we talk about trying to come to terms on development of humanitarian norms in cyberspace. So it will be interesting to understand, again, what capabilities do they have offensively and defensively. And it's really a realm that it's difficult for us to get our heads around, but we're all trying to start to do that.
Thank you. Thank you for going through that. We received a couple of questions regarding cyber warfare, so that was helpful. There is also a question, and I think that's a big point of concern for humanitarians now, which is and you mentioned a little bit in a presentation about counterterrorism and how that affects humanitarian response. And hold on, I'm trying to find here. I'm getting so the question from Donna Stefano is, how do we become better advocates bilaterally with our donors who put in no contract restrictions with non-state armed groups that hampers the delivery of humanitarian aid? And she mentions here the recent case in Yemen.
Well, let me start by saying, in fact, I think the recent case in Yemen, now we're kind of moving into a slightly different domain here because we're talking about donor contracts and our ability to operate, but it's still relevant towards the ability to have discussions and engage with armed groups. So in fact, I think what we need to do is consider the recent sanctions in Yemen that were imposed and then withdrawn by the US as a really positive development. And here I'm not only talking about the withdrawal of the sanctions, I'm also talking about the real substantial humanitarian carve-outs that those sanctions granted through a licensing system, where, for example, specific organizations such as the ICRC were granted blanket exceptions together with the UN organizations. But in fact, beyond that, civil society actors in general were granted broad exceptions as well. You know, I won't go down more into the weeds of this because it's a discussion in its own right. But what I think we do have here is we have a really good example, because sanctions probably aren't going away, whether one likes them or one doesn't like them. But what is really important is that these humanitarian exemptions exist so that humanitarians can continue to do their work, including this type of collecting perspectives, dialogue with armed groups. So in that sense, these recent sanctions set a very interesting example. And we hope that just because the sanctions are gone, which from a humanitarian perspective is also a great outcome, but just because they're gone, that we don't lose sight of those carve-outs that were granted, and that these can provide incentives for future sanctions regimes.
Thank you. Thank you so much, Jonathan. Our next question here is, what would you say are the next opportunities to bring armed groups to the table at the international level? Are you engaged with states to discuss possible presence of non-state armed groups at this point? And if so, what are their reactions?
I don't know, maybe I should start, but then I think it would be good if you share a bit further your experiences with the Safe School Declaration. I think that's kind of, because I think that's quite recent. But I mean, we for instance, yeah, I mean, we talked to states about this. Perhaps again, if we go back to the first chart that we presented, in some of those activities, states are actually involved, and they come and they hear what non-state armed groups say about international law. The question again is how to move forward from that, listening to the problems that armed groups have when they try to comply with international law, to a different, to developing a different legal framework, or adapting certain rules, or how we translate those problems and those discussions to the legal arena. And that's of course challenging, but in international law there is always again this assumption that every state is a gatekeeper, and they try to keep for themselves the power of lawmaking. And of course, again, I think I would try to be cautious. I'm not sure. Yeah, I think it really depends on the process that we're dealing with. So if it's a soft law document, if it's a, I mean, yeah, I think even for lawmaking processes for states, by states, is already quite challenging. And we have seen this in different tracks organized in the last few years on different thematic issues, such as detention, for instance. So it's already very difficult for states to gather around and discuss about international law. So I think for armed groups, it might be difficult as well, but it's not excluded.
Yeah, I'm going to use, actually, Ezequiel, if you don't mind, a slightly different example. It's the example of the International Law Commission Special Rapporteur on Environment and Armed Conflict. And so in the International Law Commission, there were several rounds of discussions among states on, you know, what should international law, international law with respect to the environment and armed conflict be. And the former Special Rapporteur, Mary Jakobsen of Sweden, actually in one of her reports said, you know, it would be really good if we could actually reach out and gather the perspectives of armed non-state actors in this area, because that would help us not necessarily to understand what international customary law would be, because there's a lot of discussion, in terms of whether non-state armed groups could contribute to international customary law. So that wasn't necessarily the point, to understand what the law was, but to understand, again, what's the context? What are the issues? How do we understand what it means for these very significant parties to the conflict? And so I think there's something about normalizing this, and that goes towards normalizing it. And the more we do it, the more it's normalized. I was also involved in another conference on education, where again, UN officials were involved, and they were hearing reports by the non-state armed groups on the situation of education in territories where they control. And they walked away being, that was incredibly enlightening. And their eyes were wide open, UN officials, because they'd heard things that they hadn't heard before, and they were able to contemplate things that they hadn't heard before. So again, that's bringing the perspectives, but that was kind of an expert meeting. It wasn't something that then jumped up to, well, what do we do now with this knowledge in terms of norm creation?
This is very illuminating. Thank you so much for contributing to this. We have reached our hour here, but we still have a couple more questions. Do you guys still have a couple more minutes to answer these questions? Okay, so I will read a couple of them, and then you can address at the order that you feel appropriate. So the first one, Yvette is asking about the impact of non-state armed group fragmentation on your work. And if you could speak to the challenges that you face in terms of engaging with such groups in that environment where fragmentation is so widespread. And it seems, and she points out, seems that even the inform function would be difficult to achieve with fluid groups, and the norm generating development function even impossible. Curious to have your views on this. So this is first question. And then let me just go back to trying to comb through. I want to make sure that I don't miss any questions. And Ron Reitman is asking about, if you can just speak a little bit about how, why are you using the term non-state armed groups again? And he asks about, why would you include non-terrorist organizations if those are also included into the same bucket as non-state armed groups? If you can just quickly just explain that determination for him, why we use that.
I didn't quite hear, and then you include, so I missed out on part of the question.
He's asking on what groups to include or exclude as non-state armed groups, and if that includes terrorist organizations. So if you can just explain it to him a little bit on how that works, that characterization. And yeah, I think those are the last two questions that I have here. If you can address that, please.
I go, you go?
Go for it, then I'll
No,
follow.
just, I mean,
take both of them at a time, and then I'll take both of them as well.
Yeah, I mean, I think it's easier, the second one. So non-state armed groups, I mean, they can include, of course, what domestic law or certain states or regional organizations call as terrorist organizations. I mean, this is a term that we have used, but other terms have been used depending on the stakeholder that is referring to this actor. So, I mean, we use non-state armed group, but we are referring mostly as non-state parties to armed conflict, to non-international conflict. So non-state parties that are bound by international humanitarian law. And it doesn't matter if for a state or a regional organization that non-state actor is a terrorist organization or not. I mean, for certain regional organizations, a non-state actor might be a terrorist organization. For others, it might not be. So it really depends on who you're talking to about which non-state armed group. The question of fragmentation, I think that's, I mean, I have two quick thoughts about this. So I would say that they're more centralized and organized non-state armed groups that we tend to think. So now we discuss more and more about fragmentation of non-state armed groups and the challenges that we see in terms of compliance, etc. But there are still non-state armed groups with a very high level of organization and structure existing out there, and willing and interested in dealing with international law issues. So yeah, that's but and for me, fragmentation is not necessarily something new. I mean, of course, we talk about that more often now that perhaps people would talk about that in the 90s. And yes, it might be a challenge, but then, you know, there's some people saying that, I mean, if you actually provide, for instance, if we go to Inform and you are an international humanitarian organization and you engage with a group and you provide IHL dissemination, and that group then it fragments, it splits into two other groups. That doesn't mean that the Inform activity did not actually achieve anything. I mean, those people still had received dissemination sessions on IHL, and now they're part of a splinter group, but they still have received those dissemination sessions. But yes, it's going to be more challenging in terms of saying, well, you know, that you collect the views and then suddenly that group is 2 groups or 3 groups, and then in that respect, it might be more difficult. Jonathan?
I mean, I think the ICRC estimated at one time, and thanks of that, we thought we were cruising through to the end here, and then you put in a fragmentation question. But I'm glad we get a chance to address it. ICRC has said at some point in Syria there was upwards of 4,000 armed groups. So, I mean, on one point, it's just a pure manpower issue. I don't think we have the resources to go and engage 4,000 different armed groups. But so certainly it is a challenge of the day, but I do think that there's an ebb and flow in this, in the way that conflicts look, in the way that conflicts looked 100 years ago, 50 years ago, 30 years ago. And so, I think if we're thinking of this in the long term, we also have to consider how are armed groups going to look in the future. And, I think we're heading into a world that at least is perceived very differently from great powers than it was even 5, 7, 8 years ago, coming out of the post 9/11 world. So again, let's try and play a long game on here. Let's identify and recognize some of the challenges, and certainly fragmentation is one of them. But let's not get completely tripped up on some of these issues, because as Ezequiel says, there's still plenty of fish to fry that aren't necessarily fragmented. So let's at least start there. And then on terror organizations, actually one time I tried to go through, and the caveat is it was a Wikipedia list, so take it for what it is. But just to try and get an idea, of all the kind of terror listing regimes of different states and different organizations, was there any group that made it across the board? And so I looked, and I could say there was not one organization or entity that was listed as terrorist by all of the states or regional organizations that were listed in this chart and table. So I think that's a great illustration of one man's freedom fighter is another man's terrorist, or the other way around. Certainly the discourse is challenging. But, again, what we try to say is judge on what they do, not what they are or how they're labeled, because they do need to be judged on their actions. And by engaging them and by bringing their perspectives out, it actually, as we said before on the question of impunity or accountability, it actually then puts them more in the limelight and makes them more accountable. So again, terror discourse is a political discourse. It doesn't mean by not engaging in a terror discourse, it doesn't mean that you're validating these groups in any means, but it means that, again, you're applying the IHL paradigm where equal rights and obligations are imposed on state and non-state parties to conflict. And so how do you act and how do you try and gain compliance? Because that's an equal set of rights and obligations, but it's an apples and oranges world, because it's states that control international law and decide international law. So it becomes tilted and slanted, but we still have to operate in this environment because, again, we're looking for the best humanitarian protection possible.
Well, thank you so much, Jonathan and Ezequiel, and thank you for closing with that that need to look at the humanitarian imperative first and foremost. And we're just very thankful for your time. Thank you for being so generous and staying with us 10 minutes longer here. For our participants, if you have any additional questions, please email it to us. We'll be happy to help answer that for you. And yeah, thank you so much again for being here with us and for sharing your expertise. Christian, do you have anything to say before we close out?
No, just thank you again for sharing your time and expertise with us. It was illuminating for me as well, and I know to everyone else who joined us. So thank you again, Manitak, Jonathan, and muchas gracias to Ezequiel. Thank you very much. And thank you all for joining as well.
Thank you very much.
Okay, you'll make it easy. I'll just say goodbye. And thank you.
Favel.
Bye-bye.